Welcome back to Hardball. George Zimmerman's attorney will try next Friday, April 20th, to get Zimmerman out of jail while he awaits a trial for the shooting death of Trayvon Martin. Meanwhile, the judge in the case brought up a potential conflict of interest this afternoon when she announced that her husband's colleague, a CNN legal analyst, had denied Zimmerman's request to represent him last month. Joy-Ann Reid is the managing editor for thegrio.com as well as an MSNBC contributor. She's in Sanford, Florida tonight with the latest. Joy, what's going on?
Well, at issue, basically, is that the judge in this case, Jessica Rexseidler, her husband, Jason, is a civil attorney in the law firm of a guy named Mark Nejame. And if that sounds familiar to you, Michael, it's because he has the nickname the Johnny Cochran of Central Florida. He represented Tiger Woods after that infamous car crash in his home where there was a golf club apparently involved. And he also, in the past, represented the parents of Casey Anthony in that huge trial here. So this is a very prominent attorney who apparently was contacted very early on by George Zimmerman before he got his first set of attorneys to represent him. He declined to do so, but that contact with George Zimmerman and, more importantly, with his parents is what's now concerning Mark O'Mara, who is essentially saying this. He's saying this is a guy who's had contact with George Zimmerman's parents in the past. He's now an analyst on CNN. That combination worries him because he's worried that, you know, potentially that contact could happen again.
I find it unusual that a defense lawyer would turn down such a high-profile case. Do we know anything about his rationale?
We don't know why he turned that case down. I believe he had other cases at the time, but he did give a reason, obviously, to George Zimmerman why he didn't take it. And then in between him and Mark O'Mara, of course, we had Hal Uhrig, another set of lawyers. But what we do still know now is that the judge disclosed this herself. She went ahead and disclosed the potential for the appearance of conflict, and now she's leaving it up to Mark O'Mara, to the attorney, what he wants to do. He could actually file a motion to have her removed and have her replaced with another judge.
A week from today seems like it'll be a significant date in the chronology of this case because that's when O'Mara will try to have George Zimmerman released from jail.
Absolutely, Michael. And here's the issue. The previous attorneys for George Zimmerman had made a big issue of the idea that he's unsafe in this community, that people in this community, particularly in the African-American community, are sort of out to get George, that he wasn't safe. So it's a question now why he would want to be released right back into this community.
Where would he go?
So I did ask leaders in the African-American community as well as the mayor of Sanford, you know, what do they think about this? And from the police department, which said that they'd be prepared if necessary, to the mayor, who said that the city would be prepared, to black leaders who said, frankly, look, there's a process in place. African Americans here are satisfied that a process has begun and would do nothing. So it's pretty much been across the board that he wouldn't be in any danger. But it is an interesting contrast to what was said before.
Joy-Ann Reid, thank you so much for your report.
Thank you.
With me now, criminal defense attorney, famed criminal defense attorney, Mark Garagos. Hey, Mark, thank you so much for being here. You know how much I respect your legal opinion, and I also respect the legal opinion, thank you, of Harvard Law professor Alan Dershowitz, who last night, right here, made some news with his take on the affidavit of probable cause. Will you please watch Professor Dershowitz and react to this?
Most affidavits of probable cause are very thin. This is so thin that it won't make it past a judge on a second-degree murder charge. It's not only thin, it's irresponsible. I think that what you have here is an elected public official who made a campaign speech last night for re-election when she gave her presentation and overcharged, way overcharged. This case will not, if the evidence is no stronger than what appears in the probable cause affidavit, this case will result in an acquittal.
Mark Garagos, your thoughts?
Well, I don't disagree at all. I stated publicly when I saw the affidavit that this was about as bare bones an affidavit as I've ever seen, and I would agree with the professor. In fact, I suspect that there has to be more. Otherwise, I don't know, in the part that I might disagree with, I don't know that it gets to a jury. Remember, they have this kind of unusual two-step process in that besides having a probable cause proceeding, they also have what's called an immunity proceeding and the stand your ground proceeding, where it's a determination by the judge as to whether or not to grant immunity. If the judge finds that he was acting, and it's just by a preponderance, a little bit more than the other side in terms of the evidence, they could grant immunity. This would never see a jury.
I guess many of us were looking at the affidavit of probable cause for a sign of what the prosecution believes took place that caused the attack or the altercation, whatever it was, to begin. And here's the critical paragraph, and I'll put it up on the screen. Zimmerman confronted Martin and a struggle ensued. Witnesses heard people arguing and what sounded like a struggle. During this time period, witnesses heard numerous calls for help, and some of these were recorded in 911 calls to police. Trayvon Martin's mother has reviewed the 911 calls and identified the voice crying for help as Trayvon Martin's voice. Now, as you point out, Mark, they arguably have much more than this, but they're not telling us anything as to why they disbelieve Zimmerman. Presumably, he's offering an account that says, I was not the initiator.
Right, and presumably, at least if you believe the police report, when they got there, he was wet, he had grass on him, he was bleeding. The way that narrative you just read comes off, that's still a self-defense, that still falls within stand your ground. So that alone, I don't believe, ever gets you to a jury. That having been said, that's if you're taking a dispassionate view. I mean, there's a lot of us who believe that the standard for probable cause nowadays is my client breathing, and that most judges will let you just go to trial on anything.
All right.
That having been said again, well,
let me ask you something else, Mark Garagos, with your experience. I found it unusual, but my expertise is all on the civil side of this, that Angela Corey, the special prosecutor, the state's attorney, was in that courtroom yesterday and agreed with an effort by defense counsel for, at least the time being, to seal all the records. Read the tea leaves. What do you make of this?
Well, I think that one of the problems that the prosecution may have is, for whatever reason, they don't want what they have, all of the evidence that they have, released. I mean, one of the problems you have in a case like this is that virtually everything ends up getting released. It gets parsed out by the media and in the public sphere. And when that happens, a lot of times that affects witnesses and everything else. I wouldn't read any nefarious connotations into that.
Well, it's not that it was nefarious. I wasn't reading anything nefarious into it, but maybe I was reading too much into it in thinking that perhaps there's a plea deal already being discussed.
Well, you know, that is something that I wouldn't be surprised. A lot of people have talked about, look, it's a second degree. During the Conrad Murray case, I was always kind of perplexed as to why the LA DA didn't file second degree, because what that does is when you're facing life and you've got a second degree, somebody offers you a manslaughter with a fixed number of years, you've got quite an incentive to take that plea deal.
You pointed out previously that the real critical juncture is going to be the stand your ground evidentiary hearing. Would you expect that Zimmerman would take the stand at that hearing? And if he's unsuccessful, what does that do to his testimony and his Fifth Amendment rights for the final trial?
Well, I'm not going to pretend to be an expert on what Florida law allows. I would expect that he does take the stand, or at the very least that they, if they're allowed to do it, they put the officer on who took his statement that evening and get it in through hearsay, if they can do it procedurally. Either way, they need to get his statement in, because you're not going to be able to prove stand your ground unless his statement that he gave to the police the night of the incident is in evidence, or he gets on the stand and tells what his statement is or what his state of mind was, and then allows the prosecution to impeach him with whatever his statement was. But either way, I expect that you're going to hear the words of George Zimmerman at that stand your ground hearing.
Mark Garagos, thank you so much for your analysis. Have a good weekend.
Thank you. Glad to see you.